Good afternoon, guys. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, I would like to provide you some quick updates regarding the most recent immigration news. Well, first of all, a very important update is that Executive Office of Immigration Review is changing the way the cases are going to be handled in immigration courts. And this update concerns everyone who is currently in immigration court or can be placed in immigration court proceedings. Let's say you're waiting for your asylum interview, or you don't have legal status and potentially you can be placed in removal proceedings. So you need to know what to expect in immigration court. It's very, very important. So previously, you may be aware that if you are referred to immigration court, you're served with a notice to appear, and the immigration court is going to give you a date for what's called a master hearing. A master hearing would be a short preliminary hearing where a judge, your attorney, government will discuss some issues about your case, will set up the deadlines, and your lawyer is going to enter pleadings or answers to the allegation in the notice to appear. Answers to the allegation as to why you should be removed from the United States and your defenses to the removal proceedings against you, if you have any. After the master hearing, the judge will set the date for another master or for the individual hearing, depending on the circumstances. And before a person's presence would be required for the master hearing, you would have to come in person to court. And those master hearings sometimes can be very, very crowded. There will be like literally maybe 100 people trying to get into one room where the master calendar is being held. So now Executive Office of Immigration Review is changing that order. What's going to happen now, according to the latest memo they sent, is that if the person is represented, and this change is going to be only about those people who have an attorney and who are non-detained. So if you have a lawyer and your lawyer files a notice of appearance at least 15 days prior to a scheduled master hearing, that master hearing is going to be canceled and you will not have to physically come to court. Instead, an immigration judge is going to issue a scheduling order, an order that directs your lawyer to submit answers to the allegations against you or pleadings. And the default time will be 30 days after the master hearing, or the judge may state how many days your lawyer is given to submit those pleadings, written pleadings. After the court receives the answers to the written pleadings, the allegations, the court is going to either sustain the charge of removability, meaning that the court is going to agree that yes, the person should be removed. But now, are there any defenses to the removal? And the court is going to give yet another deadline to your lawyer, now to submit applications for relief. And the default time for that will be 60 days or 2 months. Once your lawyer responds to that portion of the scheduling order, then the case will be screened for being trial ready or not being trial ready. And if the case is trial ready, the court should place it on the calendar for the trial within 90 days from the order that says that the case is trial ready. So what I take from it is that basically the immigration court is going to aim at processing the cases very, very fast, or within about 180 days altogether. I understand that at the beginning this probably will not be achievable just because the judges' dockets are very, very busy. But with time and adding of more judges, this probably will be the new model that we need to get ready for. That as many issues as possible will be decided out of the courtroom, and the lawyers, of course, will be very useful here because the majority of the work will be done by the lawyer and the paperwork with the help of the lawyer. And of course, the problem is that currently the judges are still not having the capacity to process the cases so fast, but I understand that the Biden administration is going to make necessary changes to provide support staff and perhaps increase the number of immigration judges so that the new case flow model is going to develop, take full force, and we're going to see that it takes just about 6 months to a year for any case to be processed in the immigration court. Now, which cases are going to be subject to that? Well, basically, as I stated, cases for non-detained hearings, cases where the pleadings have not been done yet, cases that do not have the individual dates set up for them, pretty much all those cases. And you should check with your attorney if your case will be subject to this new order. And if you don't have a lawyer, all I said is not relevant to you. You will still have to come to court. You will have to basically abide by the deadlines that the judge is going to give you during the master hearing. So this new order is only for those who do not have, who have lawyers, okay? And if you don't have a lawyer, this new order does not apply to you. It also does not apply for unaccompanied minors and detained clients. But this is something to keep in mind also, because previously a lawyer could have years between the time that they take the case and the case is going for individual hearing. And the documents would have to be constantly be updated, and we would not know when to send those updates because the hearing date would be moved several times and several updates would be required. So now I understand that the court would like to organize everything much better. So there will be certain very set deadlines as to when you are sending your application for relief, when you're sending additional documents, if any. It's actually 30 days before the trial according to the new model. Previously we had 15 days before the trial, so now we have less time, right? Less time. So you just need to know about this and prepare for that, meaning that if you're referred to court, you need to expect that everything will be developing very fast, and you will no longer can count on those years to pass between the time that you're referred to court and the time of your individual hearing. Just something to keep in mind. Another update, very interesting update, is that the Board of Immigration Appeals held that New York conviction for aggravated unlicensed operation of a motor vehicle is a crime of moral turpitude. Why is it important? Well, it's important because many immigrants who do not have driver's license are driving in New York, and this is quite a common charge that they would face. They would face a charge of unlicensed operation of the motor vehicle, but we're talking here about the aggravated unlicensed operation of the motor vehicle. It usually happens when a person already knew that they couldn't drive, or their driver's license is suspended. They shouldn't be driving, and they're nevertheless operating the vehicle, and very often they're also under the influence of some sort of controlled substance or alcohol. If you or you know your family member had a conviction like that, you absolutely have to talk to an attorney, because if a conviction is labeled as a crime of moral turpitude, it may prevent you from getting a green card, it may prevent you from qualifying for the immigration reform, it may have serious consequences for you even if you have a green card already. You need to know about that. All right, so this is the recent change for New York cases. Another update is that you may be aware that there are a lot of delays, very long delays currently when you're submitting your adjustment of status applications. You do not get receipts for months. Many people are anxious and they submit a second application with fees, of course, just to make sure that they are complying with deadlines. Sometimes people have deadlines. So USCIS stated that if you are sending a duplicate application, second application, just to cover yourself, they will not refund you the filing fees. Just something little to know. Okay, they will not refund you the filing fees. And at times you have to make sure that your I-45 is submitted, because you may be aging out, or you may be losing your non-immigrant status, and you have to show that there is an adjustment of status pending. So this is an interesting update. So if you want to make sure that your application was submitted on time and you have to refile, they will not get you that money back, just so you know it. And finally, people are asking me about the immigration reform. What's happening with it currently? Well, nothing is happening this week, because immigration reform, the next step we're expecting from the Senate. Senate is on recess, and they're going to resume their activities next week. So I anticipate any meaningful updates to be happening only next week. All right. So this is all for now. I hope that you find these updates helpful. Please subscribe to my channel, like, share this video, and thank you very much for watching. And I hope to see you soon.